Welcome everyone, thanks for coming. Today we're going to be having a look at the role of the Australian Constitution, which will also include the division of powers and the separation of powers. So first and foremost, Australia, as you know, is a democratic society and it generally has a pretty good human rights record. People around the world seek to live in nations like Australia, New Zealand, the United States of America, Canada and Britain on account of their approach to human rights and the opportunities these nations give to people. However, despite the good overall human rights record of Australia, there are some justified criticisms, such as how asylum seekers are treated, the treatment of Indigenous Australians in the criminal justice system, and the treatment of minority groups with respect to fully equal representation in politics, business and government institutions. Now, the Australian Constitution supports human rights protections through a number of different means. This includes the separation of powers doctrine, the division of powers between the Commonwealth and the states, through express and implied rights, and as well as the nature of the Constitution as a document that is actually very difficult to amend or change. Now, each of these aspects of human rights protection will be explored in a bit more detail. Now, regarding the separation of powers, this involves chapters 1, 2 and 3 of the Constitution because it does not actually state that governance should be separated into three distinct arms of power. However, the structure of the Constitution does strongly imply that this is the intention of the document, mirroring in this regard the Constitution of the United States of America. This evidence of this intention can be seen in the structure of the first three chapters of the Constitution. Now, in Chapter 1, the Australian Constitution outlines the structure of the Parliament, detailing the bicameral system, the roles of the lower house, which is the House of Representatives, as well as the upper house, which is the Senate. Through the creation of a bicameral system, human rights can be better protected in Australia. This is because the upper house acts as a role of review and can amend or change proposed laws in order to better reflect the needs of more people in society. In Chapter 2 of the Constitution, there is an authority for setting up of an executive with a view to creating a self-government in Australia. Whilst historically significant, the main powers of the executive are derived from the powers allocated to the Commonwealth in Section 51 of Chapter 1. This is hugely important. Now, in Chapter 3, the Australian Constitution sets up the judiciary. This aspect of governance is extremely important in carrying out the independent enforcement of the law and the imposition of sanctions. Talking about the effect of the separation of powers on human rights protection in Australia, we need to compare to other nations where there is no separation of powers. So, that would mean where the full expression of human rights for those citizens are not upheld. Several nations can be compared here where the military has taken over the government, so we can have a look at Fiji, Burma and North Korea. We can also see how the judiciary is replaced with military officials. So that is a big issue there. You start having a look at dictatorship issues, too much power on one arm of the government. Now, in Australia, the appointment of the judiciary is independent and must have bipartisan support from both main political parties. So that means Labor and the Liberal coalition must agree. The effect of the separation of powers into three arms, that is the legislature, executive and the judiciary, is to provide a system of checks and balances. Really important that you know that for your exams. This means that no single aspect of government has unfettered power and that the government is subject to limitations on its own power. Further to that, the government decisions can be reviewed through an independent judiciary. I cannot stress just how important that is. Okay, a second source of human rights protection arising from the Australian Constitution is from the division of powers. Now, the division of powers is a reference to the allocation of the different lawmaking powers of the Commonwealth compared to the states. Power can be classified within three different categories. Exclusive powers of the Commonwealth, which are articulated under Section 51 of the Constitution. Residual powers that vest with the states. These powers are those which were historically with the states prior to the creation of the Commonwealth of Australia. And concurrent powers are those that are shared by the Commonwealth and the states. Now, the purpose of the division of powers is to ensure that the states retain their powers and can pass laws on a more localised level that are relevant to the people living within their state. It also ensures that the Commonwealth will concern itself with issues of the Commonwealth, such as defence, the Australian dollar, customs and international trade. The effect of the division of powers for the states is that they are all treated equally, and there is no person disadvantaged as a result of where they are born or where they live. Furthermore, each of the states retains its own identity because it can pass its own laws with respect to health, transport, education, policing, as well as housing, which is hard to see just over here. Now, concerning the difference between express and implied rights in the Constitution, express rights are really, well, they're explicit, they are written down, they are specific. Implied rights are read into and actually take judicial decisions to be clarified. So express rights in the Constitution are from Section 7 and Section 24, which includes the right to vote. Now, the right to vote as articulated by the representative of the House of Representatives and the Senate to be freely chosen by the people. That is, the right to freely choose gives people suffrage or voting rights. Section 51, paragraph 31, this section of the Australian Constitution says that the Commonwealth has the right to acquire, that means take land on just terms. What just terms means is if the Commonwealth wants someone's property, that might be to extend an airport like Sydney Airport or one of Melbourne's airports, that it must buy it for fair value or market value. Section 80 is the right to trial by jury for an indictable offence. Whilst this right is articulated in respect to Commonwealth offences, the state also gives their citizens this right. Section 116, which has been caught out over here, is the right to freedom of religion, that is the freedom of belief. That is expressed, that has come up in a few past HSC exams, so you need to know that one. And lastly, because it was cut off from my slides, Section 117 is the right to be free from discrimination on the basis of which state a person lives in, so whether it's Queensland, New South Wales, Western Australia or Tasmania. Therefore, the right to be treated equally regardless of residential location. Now, when concerning ourselves with implied rights in the Australian Constitution, the right to freedom of political communication has been interpreted to mean freedom of speech, and has been held as an implied right from Section 7 and Section 24 in combination with each other. And this right has been clarified by the courts. So this right has been clarified by the courts as necessary if people are to freely choose their representatives. This means that political communication is essential and a discussion and critique of different positions is therefore also necessary. Now, Section 109 deals with the situation that occurs when there is an inconsistency between the state and Commonwealth laws. The Australian Constitution states if there is such a conflict, the Commonwealth law shall prevail. That is a higher law, federal versus state. So, therefore, the states will not make laws that are contrary to Commonwealth Parliament. Section 128 is particularly significant with respect to human rights protections in Australia. Now, particularly because a document like the Constitution needs to be stable, it is therefore very hard for the Constitution to be changed or amended. It can only be changed through a referendum. Now, a referendum requires a successful vote in favour of the change by a double majority. Now, what is a double majority? A double majority is a majority of voters and also a majority of the states must vote in favour of the proposed changes. So, what that means is even if the majority of voters in the two largest states of New South Wales and Victoria vote in favour of change, but 4 states vote against the change, like Queensland, Tasmania, South Australia and WA, then the vote will not be carried forward. Now, guys, that's it. What I want you to do is work through your worksheets, make sure that you have a thorough understanding. As you'll see from that Socrative quiz, there's quite a bit from the multiple choice sections of your HSC that could come up from just this topic alone, looking at the Constitution. Thanks, guys.